For many people, divorce becomes stressful the moment paperwork enters the picture. Not because the decisions are impossible, but because the forms feel unfamiliar, rigid, and intimidating. People often think the forms are the process. They are not. The forms are simply the way court records decisions that have already been made. Today, I'm going to walk you through the most common divorce forms used in Connecticut, what they are, why they exist, and where they fit, so the paperwork stops feeling like the obstacle. Now, this is for informational only and does not constitute legal advice. Welcome to Compass Mediation CT, where clarity comes before conflict. One of the biggest misconceptions about divorce paperwork is that the forms decide your future. They don't. Forms are administrative tools. They document agreements, disclosures, and required information so the court can close the case properly. When people understand that distinction, anxiety drops because the focus shifts back to decision making, not form filling. In Connecticut, a divorce formally begins with a small group of foundational documents. The summons tells the court a family case is being opened. The divorce complaint explains the basic legal reason the marriage is ending. And the automatic court orders establish temporary ground rules while the case is pending. These forms don't resolve anything. They simply open the door to processes. Understanding that helps people stop reading them as threats and start seeing them as structures. Now, the financial affidavit is one of the most important documents in a Connecticut divorce. Its purpose is to disclose, not negotiate. It provides a snapshot of income, expenses, assets, and liabilities, so decisions can be made with accurate information. Many people fear this form because it feels personal, but it exists to prevent surprises later. Clarity early reduces conflict later. If children are a part of the marriage, additional forms are required. These documents confirm basic information about the children, the living arrangements, and support consideration. They are not parenting evaluations. They are not custody rulings. They exist so the court can ensure that statutory requirements are met and that children are accounted for in the process. Again, documentation, not decision making. In mediated divorces, the most meaningful document written is agreement. This is where decisions live. Property division, support terms, parenting arrangements. It's called the Marital Separation Agreement, or MSA. The agreement reflects the work done outside the courtroom, often through mediation, and is later submitted so the court can approve and finalize it. The court doesn't design these terms, it reviews them. That's why clarity before paperwork matters so much. Connecticut also requires forms that confirm both parties are properly involved in the case. You have appearances, waivers of service, and certifications exist to protect due process. They ensure no one is excluded, surprised, or bypassed. These forms don't advocate conflict. They prevent procedural problems. All Connecticut divorce forms are available through the Office of Judicial branch website. Using official sources matter. It ensures you're working with current, accurate documents. Now, links to the forms discussed in this video are included below for reference. They're tools, not instructions on what you should do. Divorce forms are not the divorce. They're the record of decisions already made. When people slow down, understand the process, and approach paperwork with clarity instead of fear, outcomes tend to be steadier, and regret is less common. Understanding forms won't tell you what to choose, but it can help you understand where you are. I'm Aaron, and I help Connecticut couples divorce with clarity.